Welcome to Chapter 1, Week 1. We're going to start off obviously by doing just a brief introduction to law. As I mentioned earlier, this class is really an introductory class. And even though we go into some of the topics in a little bit more depth than you would in BUL 3130, for example, if you were not an accounting major, it still is what I would call a survey of the law in general. Having said that, these are the main topics that we will be covering in Chapter 1. Number 1 is the nature of law. In other words, what is law? B or 2, classifications of law. In law, we always like to, we have several classifications, and that's what makes it difficult a lot of times when you're a law student, is trying to keep all the different classifications in place. And we'll talk a little bit about some of that. C, sources of law, probably one of the most important aspects or areas in this Chapter 1. It's very important to understand what gives rise to the law and also the hierarchy of the law, because there is a hierarchy when we're talking about sources of law, which becomes very, very important in understanding exactly how law works. And we'll finish up the chapter by discussing or talking about legal analysis. Again, very, very important. Any legal problem, really, the bulk of what a lawyer does is the lawyer analyzes that problem. And so we're going to discuss exactly how you would analyze a particular situation or set of facts from a legal perspective. So let's go ahead and get started with the first part here. Let's talk about the nature of law. In order to do that, in order to discuss what the nature of a law is, it's important to have a really very general, very broad definition of what law is. And that's exactly what we see here and exactly what the book provides is a very general, very broad view, which is a rule of civil conduct prescribed by the supreme power in a state, commanding what is right and prohibiting what is wrong. And that comes from Blackstone, which is a very important source of legal definitions in general. Now, there are many other ways that we can define law, and usually law is a reflection of the accepted norms of a particular society at a particular point in time. And so that's why law is almost flowing in nature, meaning that at least in our in the common law jurisprudence or legal system, and I'll talk a little bit more about the difference between common and civil law later, but in our system of law, again, we're in a common law system. Law is not rigid, right? So it does vary. So it changes with time. It changes with the social norms. Things that may be acceptable today may not be acceptable 100 years from now. Things that are legal today may not be legal 50 years from now. A couple good examples of that is, for example, marijuana. We've seen a huge shift in the laws regarding marijuana in the last 20, 25 years. It used to be that if you went back to the 1980s, for example, and I'm using the 1980s because the government, the federal government, in particular under the Reagan administration, elected to pursue drug policy or drug enforcement as one of its priorities. And there's always been a big drug problem, but in the 80s it was particularly noticeable in Florida, especially, and in Miami. There was a lot of cocaine that was coming through. In fact, if you've ever heard of the cocaine cowboys, that's where all of that comes from. So there was a lot of enforcement or a lot of emphasis from the federal government in enforcing laws. And so if you would have asked somebody back in the 1980s, or if you would have told him or her that, hey, marijuana is going to be legal, whether it's for purposes of medicine or even the other extreme, which is recreational, they probably would have laughed at you at that point. And so I don't think anybody would have foreseen that at that point in time, because that was the way the laws were at that particular point in time. That was not acceptable. Now we've seen that there's been a shift in the law, where now many states are using marijuana not only for medicinal purposes for medicine, but also recreationally. Colorado, for example, I think California just enacted a law for recreational purposes as well, and we're starting to see that in Florida, not for recreational, but we are starting to see it for purposes of medicine. So we are seeing a shift in the law from that perspective. We'll come back a little bit more to the marijuana example, because it also creates an interesting paradigm, or an interesting conflict between state law and federal law. And General Attorney Sessions just became involved in that. It's important for you guys to pay attention to what's going on in the news as well, because there are a lot of legal issues, and it moves very quickly. But again, back to my point is that the law is fluid. It changes. It's not rigid. You'll see changes over time. Another example of, well, I'll come back to it, but segregation is another good example of the law evolving or changing. Um, Gay marriage is another example, recent example that we've seen. So, also when discussing the nature of law, it becomes important to understand what the function of law is. And in essence, at a very basic level, the idea of law is to maintain stability in the social, political, and economic system through a dispute resolution mechanism, right? Protection of property and the preservation of the state, while simultaneously permitting order change. And that's what I meant by this fluidity, right? That we do allow for change in the law, so that the law can adapt to the changes in social norms and social customs. But what is important also, if we're going to look at it from an economic system, and in particular as accounting students or accounting majors, it's a well developed legal system is what allows an economic system to thrive or flourish. You cannot have a developed economic system that functions if you do not have a corresponding well developed legal system that protects economic rights, and in particular contractual rights. And we'll talk a little bit about that later on in the semester. That is one of the main functions of the law from an economic or business perspective. And again, what the law does is it provides a dispute resolution mechanism. So, for example, when you have businessmen that engage in business transactions, and it's inevitable that disputes will arise. It's human nature. I always like to tell a lot of my clients that, hey, anytime you get into a business relationship, it's almost like a new marriage, right? You're happy, you're excited, everything's going to go great, nothing will ever go wrong, but you have to plan, right? You have to have a contingency plan in place for what if. You always got to ask the what if. What if things don't work out? What if the business doesn't generate the profits that you expect? What if there's a disagreement between the partners, parties? How do you resolve that? And that's exactly what the law provides. It provides a dispute resolution mechanism, so that disputes, and in particular, I'm emphasizing here in business disputes, because that's the role really of this class, but the idea is to provide a forum or a set of rules under which these disputes can be resolved. And what that does is it creates certainty and stability. And that's what you need for an economic system to thrive. If there's uncertainty, you could see it in the markets, for example. Whenever there's uncertainty, usually the stock market goes down. Markets do not like uncertainty. Same thing with the protection of property. Extremely, extremely important. If we do not have a mechanism in place that protects private property and provides a mechanism for not only dispute resolution, but also to enforce and protect ownership rights, then really that legal system or that economic system is unlikely to thrive or do well. Nobody wants to invest in a country or in an area where your rights are not protected. Why would you ever buy a piece of land if somebody could simply come in and just take it away from you and you really didn't have any mechanism that would protect you or would provide a forum where you could, at a minimum, challenge the other person's ability um, to do that? So that's exactly one of the functions of law, is to protect property rights and create, again, certainty and allow for people to make these types of large investments that you otherwise would not make. And the last point here in the slide, the preservation of the state, I mean, that's pretty obvious. You want to maintain order. So that's where criminal law comes in, where administrative law comes in. The government does play an important role in business and in life in general, but there have to be a set of rules in place to keep the government in check and also to create an orderly way for the government to be able to conduct its own business. So, still talking about the nature of law, a couple of things that are very important: legal sanctions and laws and morals. I'm going to speak a little bit about both of these. Legal sanctions are simply means by which the law enforces the decisions of the courts. And when we're talking about legal sanctions, we can actually make a split here. Legal sanctions can both be civil or criminal. Civil deals mainly with disputes between parties, commercial disputes, disputes between people, whereas criminal deals with disputes between a person and the state or the government. The legal sanctions really are very, very important because if we have a set of laws in place, what we call laws in the books, we don't have a means to enforce that mechanism. In other words, let's say that there's a dispute between two parties regarding a contract, and you take that dispute to the court, and the court then issues a ruling. It really is meaningless if you do not have a mechanism to enforce that ruling. So, in other words, going back to my dispute, my contractual dispute, let's say that you prevail and the court says that you are owed, $100,000 on your contract. If there is no mechanism by which you can enforce that judgment or collect on that judgment, then really the court and the process itself becomes meaningless. And so that's why legal sanctions uh, become very important. That's a way that the law can enforce the decisions of the court. And likewise, it's the same from a criminal perspective. There are certain rules that we've established, bear what I'm going to call minimums. Criminal law really is a minimum code of conduct. And what I mean by minimum, it's the minimum that we're willing to accept as a society for a particular situation, the conduct that we will accept. So if somebody breaks that norm or that law, then there's a penalty that comes with that. When we're talking about criminal law, that penalty is in the form of usually a fine or jail, depending on whether we're talking about a misdemeanor or a felony. But again, legal sanctions are a means to enforce those decisions of the court. So if the court decides that you have broken the law, usually when we're talking about criminal law, it's juries, and it's the court that actually provides the sentence or the punishment. But again, all of that are all just parts of legal sanctions. As far as law and morals are different, but they overlap. Law provides sanctions while morals do not. Morals are more related to, it's It's more a philosophical concept, and we'll talk a little bit more about law and morals when we talk about ethics. But really, morals are more related to ethics and a moral compass, so to say, our own internal set of rules that we live by on a day-to-day basis. And different people have different morals. And so, really, law and morals are different, but they do overlap because law is almost a codification, or um, we've created our laws really reflect our morals at a particular set in time, right? So as morals change, and they have changed and they do change, law will change as well. So really, law provides a what I call a floor, the bare minimum acceptable conduct, and morals usually is something higher than that. A lot of people live by a set of morals that are not just, hey, I'm just going to obey the law, but it's, I'm going to do something more than just obey the law. And that's, again, we'll talk a little bit more about that overlap and that interrelationship when we talk about ethics. Um, but that's what's important. The law does provide sanctions. Morals do not. Again, morals are just something that are either something that's acceptable by a society or by a particular group of people, and many times by individuals. Your set of morals may be different than mine. And if I fail to live up to my morals, really there is no sanction for that. There is no penalty for my failure to live up to a particular standard of or set of conduct or morals. Whereas with the law, there is a penalty if you fall below that acceptable standard that the law provides. If you break the law, there's a sanction, there's a penalty. Continuing with the nature of law, there's this concept of law and justice. They're separate and distinct concepts. Justice is the fair, equitable, and impartial treatment of competing interests with due regard for the common good. So, in other words, that's why if you see the statute of Themis, Themis is the famous Greek goddess that a lot of lawyers will use, or you may see with a lot of commercials, where it's the Greek goddess that's holding the, on one hand, she'll have a sword, on the other hand, she's got the scales, and she's blindfolded, right? And those, in essence, are the scales of justice. And the sword really depicts punishment, right? So that the law is fair. Um, the scales of justice are used in to measure competing claims or competing terms. And really, that's a fair representation of the law. The law is blind, meaning justice is fair, equitable, and impartial, or at least it should be. It's not always that way, and we've seen examples where it is not. Um, but that's how it should be. That's how law, from a philosophical point of view and from a societal point of view, is supposed to function. We want we want the legal system to mete out justice. We want it to be fair, we want it to be equitable and impartial. We don't, and again, that's why we depict Themis with a blindfold. We don't, and that's why a lot of times too, a lot of people think that the law is cold. And that's because the law does not or should not be looking at anything other than the facts and the law, and apply the law to those set of facts. And that's what we mean by justice. Justice is when the law is applied. Again, I can't say it better than the definition here. When the law is applied in a fair, equitable, and impartial manner, then justice is served. And that really is the idea behind, or should be the idea behind any legal system, is in order to be to provide justice to its citizens, whether we're talking about justice from a civil perspective, business, or criminal perspective. Again, it doesn't matter. We want whatever the outcome to be, We want that to be just. So again, there is a difference, don't confuse, between law and justice. Justice, in essence, is, again, I'm going to go back to the definition, it's the fair, equitable, and impartial application of the law. And the law is simply a set of codes, norms, and rules that we've adopted and accepted as a society and have agreed to live by and be bound by. So that would be the main difference between law and justice. Law and morals. Let's talk a little bit more about that. I know I had talked earlier a little bit about this, but for example, here's an example of law and morals. From a legal perspective, you must drive on the right side of the road if you live in the US, right? That's not always true if you live in the UK or some other countries, but in the US, you must drive on the right side of the law, on the right side of the road. So that's a law. That's a law, right? Everybody has to do it. It's in the books, must be followed. It's a rule. Let's talk a little bit of moral. A moral, you should not silently stand by and watch a blind man walk off a cliff. So, from a moral perspective, and again, right, it depends on everybody's moral compass. I would beg to guess that most people, if they saw a blind person heading off towards the end of a cliff, would more than likely reach out and help them out and say, hey, you're going to go off the cliff. Don't do that. So that's more a moral obligation. If you sit there and you watch the blind person walk off the cliff and the person dies, from a legal perspective, there's absolutely nothing the law can do because you have not broken the law. You may be unethical, you may have broken a moral standard, but more than likely, you're not going to be found to have broken the law unless there's a law that says that you have an obligation to help a blind person not walk off a cliff. If there is a law that says that, then obviously at that point you would have broken that law. But um, there is no moral. If there is no law, there is no moral obligation for you to act. Now, where these two concepts overlap, so for example, we have law and moral. So law, something that's written, something that must be followed, and something for which there is a penalty if you break, and moral, something which you should do, which as a society we would hope you do, but you don't have to, and for which there is no penalty. And those sometimes overlap. And an example of that would be the maxim of thou shalt not kill. That is both from a moral perspective. I think most people would agree that it would not be morally right to kill a person. And then from a legal perspective, the law also says that you cannot kill a person. So that is one situation where both the law and morals overlap. Doesn't always happen in a lot of situations, uh, but a lot of times they do overlap. So again, here's an example of how the interaction between law and morals and both. So having spoken a little bit about the nature of law, let's move on and talk about the different classifications of law. As I mentioned, in law, as lawyers, we like to make several classifications of law. So let's start off with one of the most basic, which is the difference between substantive and procedural law. Substantive law is the law that creates rights and duties. And procedural law is the rules for enforcing substantive law. So for example, if we go back, let's go back to the prior slide where we were looking at law and morals. Let's look at the law here. See where it says you must drive on the right side of the road? You must drive on the right side of the road there. that would be a substantive law because it creates rights and duties. And so that would be a substantive. Almost any law that you read about that's in the books that creates rights or duties, contract law, for example, it's substantive law. Property law is substantive law. Criminal law is substantive law. Procedural law, for example, would be, as as the name implies, the process or procedure that you have to follow in order to enforce substantive law. So, for example, if let's assume that you and I enter into a contract and I hire you to paint my house for $1,000. And so a we we write it out and we have a legally binding contract. We'll talk about contracts later on in the semester, but let's assume that we have a valid contract. You're going to paint my house. I'm going to give you $1,000. The law that governs that relationship, that contract, that's substantive law. So let's assume that you paint my house, you finish. For whatever reason, I don't like the work that you did, and I don't pay you the $1,000 that I agreed to pay you. At that point, you're going to claim that I breached the contract. And the whole process of breach and contract, that's all, again, that's all substantive law. Whether we had a contract in the first place, we're going to look to substantive law for that. Now, the procedural law comes where now you decide to sue me because I didn't pay you. So now procedural law tells you how you go about suing, the process. So for example, you have to file a complaint. You have to pay the filing fee. You have to serve me with a summons. You have a specific period of time within which you have to serve me with summons. So the rules, in other words, the process, that's procedural law. So that really is the best way to remember that, or to define that difference, is that substantive law are the laws that create rights, and procedural law are the rules that create the process or the rules of how you enforce the substantive law. So for example, another good example here is when you're in court, and I know many of you have seen movies, TV shows where lawyers that are at trial and there is a witness that's on the stand. One of the lawyers will be asking the witness questions, and then the other lawyer will say, objection, hearsay, or objection, foundation. There's all sorts of objections that can be raised. The objections themselves and whether something that is being asked is proper or not, those are all part of the rules of evidence. And the rules of evidence are procedural in nature. Again, it's a process, it's a set of rules as to how you conduct trials, how you ask questions. Similarly, when you file a lawsuit, there's all sorts of procedures as to how you do it, time frames when you respond to the lawsuit, how you respond to the lawsuit. Those are the types of things that we mean when we say procedural law. Also, again, as I mentioned, as lawyers, we always like to have all sorts of different classifications of law. We also make a distinction between public and private law, and this one's a pretty easy distinction. Public law is the law dealing with the relationship between individuals and the government. So, in other words, criminal law, for example, would be public law. Administrative law would be public law. So, any time, and that's how you need to analyze it, right? If you're ever faced with a question on an exam, for example, or in real life in general, if you're trying to figure out, well, is this a public law or a private law? You really have to look at the individuals. So, is the law dealing with the relationship between an individual and the government? If that's the case, then it's public law. The law that governs the relationship among individuals and among legal entities, or among individuals and legal entities, that's private law. So, for example, contract law would be private law. Partnership law would be private law. Family law would be private law. Those are all examples. And again, so really, anytime you're dealing with two individuals that are dealing with each other or with an entity, and by an entity we mean an LLC, right, a limited liability company, or a corporation, or a partnership, then at that point, that's when we're dealing with private law. That wasn't complicated enough. We're still going to have another classification of law. And you've already heard me talk a little bit about this distinction or classification, but as lawyers or in the law, we make a distinction between civil and criminal law. Civil law is simply the law that deals with rights and duties, the violation of which constitutes a wrong against an individual or other legal entity. So again, you're going to be looking at, are we dealing with a wrong or a violation of a relationship between two individuals, or an individual and a legal entity, or two legal entities? If that's the case, then that's civil. Criminal is the law that establishes duties which, if violated, constitute a wrong against the entire community. And that's why, if you ever look at, pay attention next time that you see like a TV show, or that you read in the newspaper, or even in a movie, you'll see that in a lawsuit that is civil in nature, it always have the names of the parties. So for example, Jones versus Smith, right? You know that that's a civil dispute. It's a dispute between two parties. When it's criminal, it's always the state that's involved. That's why if it's a criminal violation, if you're in court, for example, you'll see it as the people versus Jones, right? Because in essence, anytime you commit a criminal violation, it's a wrong against the state or against the people of the state. So that's why, again, you'll see United States versus Simpson, right? Or the people of the state of Florida versus Smith. Those are all types of situations. Anytime you see the people of, or the United States versus, and by the people of, I mean the people of a particular state. It'll always be like that, the people of Florida. That's, whenever you hear that, that's criminal in nature. So we do make that distinction between civil and criminal. What is interesting about that distinction as well is that obviously not only are the laws different, but also the procedures. When we're talking about the procedural, remember we talked about procedural law? The procedure is different whether you're dealing with a civil dispute or a criminal dispute. That's why a lot of lawyers practice either civil or criminal. Very few do both, because at that point it becomes a lot more complicated. You're dealing with a different set of rules, um, and a different set of laws. So the substantive law is different, but so is the procedural law. So it adds another level of complexity. So again, talking about classifications of law, here's a good diagram that's in the book that actually kind of helps you go through this process here. So the first classification is, or the first question that you need to ask when you're faced with a certain type of problem or legal situation, are we dealing with substantive law, or are we dealing with procedural law? Remember, procedural law deals with the rules, right? So if it's something that's rule related, then really you're talking about methods of enforcement with the courts, right? You're talking about rules that courts need to follow and that lawyers need to follow. And again, examples are how you file a lawsuit, time frames within which you need to respond to certain documents, how trials are handled, what the process and the procedure is, who goes first, the types of questions you can ask, the types of documents that you can use at trial, that's all procedural. Now, if you decide that it's substantive in nature, then now you have to move on to the second step in the analysis, and that is okay, we're dealing with a substantive law issue. Is it public law or is it private law? And remember, you're going to look at the relationship between the parties to make that determination. If the relationship is between two private individuals, or an individual and an entity, or two entities, then you're dealing with private law. Examples of that would be torts. We'll talk a little bit more about all of these. Contracts, sales, commercial paper, agency, partnerships, corporations, property. Those are all examples of private law. If you're dealing with public law, then you're dealing with issues like constitutional law, criminal law, and administrative law. And again, we'll talk a little bit more about each of those later on as well. Here's a good chart here that's in your book as well that talks about the comparison of civil and criminal law. So and this is a very basic, very broad overview or comparison of civil and criminal law. So for example, commencement of the action. So when the actual action begins, right? In other words, an action, same as a lawsuit, right? Or a charging document if we're talking about criminal law. So when does it begin? Well, from a civil law perspective, it's when the aggrieved individual that we call the plaintiff sues, when they actually file the lawsuit in court. From a criminal law perspective, the action commences when the state or federal government decides to prosecute the case and brings in formal charges. Usually, it's called an indictment, usually when that happens. The purpose. Well, the purpose from a civil perspective, it's usually either compensation. So again, you've been wronged, right? The contract was breached and you suffered damages. So you're asking the court to grant you the damages that you suffered. Or deterrence, right? You want somebody to stop doing something. An injunction would be an example of that. So for example, someone throws parties, your neighbor next to you throws parties every weekend well into the night, 4, 5, 6 a.m. and you're not able to sleep. So you could, that's not the best example because that could have criminal implications, but from a civil perspective, you may sue them for an injunction, and an injunction is where you're asking the court to force them to stop doing something. So there is a deterrence component. Also, in civil litigation, a lot of times there's a concept of punitive damages, and we'll talk a little bit more about that as well. But punitive damages have a deterrence effect. In other words, we want people to stop doing a certain type of conduct that's harmful. From a criminal perspective, it's a little bit different. The purpose of criminal law is to punish. There's also a deterrence component, right? Having people say, hey, I don't want to go to jail and spend 20 years in jail, so I'm not going to do that, right? So that's a deterrence. There's also a rehabilitation component. So supposedly, the idea, or at least from a philosophical perspective, the idea of criminal law was to rehabilitate the individual. Now, there's a lot of research about that and different points of view, and certain people will question whether there is any rehabilitation in our criminal system as it exists, and that's up for debate, right? Preservation of the peace, that's another purpose of criminal law. Here's another extremely important difference between civil and criminal law is the burden of proof. Civil law, it's something that we call preponderance of the evidence. And what that means is that it's more likely than not. So I would say that's just a little bit over 50%. So from a mathematical perspective, it would be like 50% plus 1. That would be a preponderance of the evidence. From a criminal perspective, it's beyond a reasonable doubt. That is the highest standard in our legal system. Beyond the reasonable doubt, I would say it's probably about 99.9%. So it's a pretty high standard. And we want it to be a high standard. Because remember, if we're going to be taking somebody's freedom away or life or property, we do want there to not be a doubt as to, or at least what we call a reasonable doubt as to that person's liability for that particular crime. And I'll talk a little bit more about that when we actually discuss criminal law in a little bit more detail. The outcome in civil law, the party being sued is either going to be liable or not liable, right? So you're either going to owe a certain amount of money or not. You're going to have to stop a certain action or not. Those are the only two options. And in criminal law, the only two options are either guilty or not guilty. I'll talk a little bit more about that when we get to criminal law as well. Not guilty does not mean innocent. That's a very important distinction. All it means is that the prosecution was not able to meet its burden of proof. In other words, they were not able to prove beyond a reasonable doubt that you committed that particular crime or the elements of that crime. Doesn't mean you didn't do it, right? So not guilty does not mean innocent. So again, that's just, we'll talk a little bit more about that later. Now, principal sanctions. In civil law, monetary damages, that's usually what most people are asking for. Whenever you sue somebody in a civil proceeding, you're asking to be compensated. So for example, somebody breached a contract. Let's go back to my example of the house that I gave earlier, right? I hired you to paint my house. You painted it. I didn't pay you the $1,000. You sued me in court. So what you're asking for are monetary damages. You're asking the court to grant you the $1,000 that I agreed to pay you, and I didn't. There are also equitable remedies. We'll talk a little bit more about those as well. I don't want to get into a lot of detail here in the introductory chapter, but a lot of times you can ask for things other than money. So for example, injunctions, specific performance, those are types of equitable remedies. From a criminal perspective, really the principal sanctions are either capital punishment, right, the death penalty, imprisonment, or fines, or sometimes it can be both. It depends on the type of crime that you're charged with, whether it's a misdemeanor or a felony, the degree of felony or misdemeanor, that's all going to determine the sanction that you'll receive. Let's move on now to sources of law. Constitutional law is the main source of law in the United States. It's what we call the fundamental law of a government establishing its powers and limitations. And we'll talk a little bit more about constitutional law later as well, but really it's the constitutional law. The Constitution is the supreme law of the land. So no law can violate the Constitution. So from a hierarchy of the law, constitutional law is the highest. There's also something called judicial law. There's common law and equity law. Common law is the body of law that's developed by the courts, and equity based upon principles distinct from common law and providing remedies not available at law. So that's just a very complicated way of saying that it's really judge-created law. In common law countries like the United States, judges create law, not trial court judges. We'll talk a little bit about the different distinctions of the court system in the U.S., but courts of appeal, and in particular the Supreme Court, whether it's the Supreme Court of Florida or the Supreme Court of the United States, they create law. And the way they do that, we'll talk a little bit more about it, but the way they do that is that they decide cases on appeal, and a lot of times they'll write a decision, and that decision will be binding on the lower courts. So that's how judicial law is created. Equity law is the body of law based upon principles distinct from common law and providing remedies not available at law. So, in other words, remedies at law would be what we call monetary damages. So, equity is a branch of the law that looks more to fairness and tries to achieve an equitable or fair result. And I mentioned some of the remedies. The remedies that would not be available at law, meaning not remedies other than damages. So again, specific performance, injunctions, those would be all examples of equity law. And again, we'll talk a little bit more about those later on in the semester as well. Legislative law is also a source of law. The government, right, the legislature creates statutes. And so legislative law is simply the statutes that are adopted by these legislative bodies, whether it's Congress, whether it's the Senate, right, whether it's the House of Representatives. The House of Representatives and the Senate together are known as Congress, right? It includes treaties and it includes executive orders that come from the executive, from the president. There's also administrative law, which are rules, regulations, orders, and decisions made by administrative agencies. And we'll talk a lot more about administrative agencies when we get to the chapter on administrative law itself. Here's what's important though. There is a hierarchy of law, as I mentioned, and this is what it looks like. The U.S. Constitution, as I mentioned, is the supreme law of the land. No law can violate the United States Constitution. Then right below the U.S. Constitution are treaties and federal statutes. By federal statutes, we mean those laws that are enacted by Congress. And there's a whole process which, in the way that happens, right? So again, we have the House of Representatives, we have bills that come out of the House of Representatives, they go through the Senate, and again, once those are reconciled and approved, we just saw an example of that with the latest tax bill, right, that came through that was signed by President Trump. So those would be federal statutes or federal law. Below that, we have federal administrative law, and these are rules and regulations that are created by administrative agencies. So for example, the IRS is an administrative agency. The EPA is an administrative agency. The FCC is an administrative agency. So the rules and regulations that they create are federal administrative law. Right below that in the hierarchy is federal common law. So again, this is the law created by the courts of appeal, the judges, the decisions that they make would then fall into this. Below that would be the state constitution. So in other words, the Florida Constitution would come next in this hierarchy of the law. Then state statutes. So again, state statutes really are the laws created by the legislative bodies of the different states, right? The Florida House of Representatives and Senate, in other words. So that would be state statutes. Below that are state administrative law, which again, we have administrative agencies both at the federal level and at the state level. So the Florida FDE, for example, would be an example of a state administrative agency, and the rules and regulations that these administrative agencies enact become administrative law. And below that, at the very bottom, we have state common law. So just like we have federal courts of appeal that create federal common law, we have state courts of appeal that create state common law. So the courts of appeal in Florida, for example, in Florida we actually have a total of 6 courts of appeal. We have 5 district courts of appeal and the Florida Supreme Court. And so the decisions from these courts of appeal then become state common law. And we'll talk a little bit more about that when we discuss the legal system in a little bit more detail. And we're going to finish up the chapter here by talking
a little bit about legal analysis. Decisions in state trial courts are generally not reported or published. Reports, decisions of state courts of appeal are published in consecutively numbered volumes, and court decisions are found in the official state reports of most states. Why is this important? Well, again, we mentioned this whole thing of precedent and the courts creating law. Again, trial courts do not create law. That's why the decisions of state trial courts are not reported and they're not published. The decisions of courts of appeal are usually reported and are usually published. Again, here it talks about these reports or reporters, where these decisions, these reports or reporters are in essence books, and they're books of decisions by different courts, and they're categorized by usually geographically is the way it works. Nowadays, it doesn't matter as much because now we do electronic research. So we would be looking for, if we're looking for decisions from a particular court or jurisdiction, we'd actually be going online. And there's really two databases that attorneys use the most. One is Westlaw, which you have access to at the library if you wanted to become familiar with it. And in fact, you'll probably have some assignments dealing with that, so you'll become a little bit familiar. And there's also another system called LexisNexis, and that's how you do legal research and conduct legal analysis. By legal analysis, what we mean is we look at the particular set of facts that you are faced with. We look to see what law applies to those particular set of facts. And then we read these reporters, whether it's in the books or online, and we try and find cases that are similar to our situation, trying to see how courts have ruled in the past when faced with these very same or similar situations. And so that's part of the legal analysis or the legal process, is we try and find cases or precedent that's similar to what we're faced with. And if there isn't anything directly on point, many times what we want to do is argue by analogy and say, hey, this case is similar to ours, and here's why it is similar to us, and so here's why you should rule in our favor. And so that, again, that's all part of the legal analysis process. So I'm going to leave this here for now. Again, this is just a very brief overview of the law, brief introduction to the law. Chapter 1, very simple, very basic. If you have any questions whatsoever about Chapter 1 in general, please email me. Please let me know. But again, I think this is just an introduction, and very brief, very basic. So this is all for Chapter 1. We'll see you next time.